Good day, everyone. Happy Sunday to you all. Welcome to today's class. Thank you for joining us early. I can see our mentor is already on call, Mr. Ebenezer. Mr. Ebenezer, sir, welcome to today's class. And all our mentees, welcome. Yes, good evening, sir. All right, today's class. This is the second quarter. This is the fourth quarter, rather, the second week of the fourth quarter of 2023 for Health Tech and Law, for our Health Tech and Law class. Before we go proper into today's class, we'd like to just take a few announcements before we call on our mentor to take today's class. And so registration is still ongoing. Right, we still give the opportunity for mentees. This is just the second class of the quarter. We expect that mentees can still catch up. So by the end of this class, towards the start of the third week, we'll be closing registration, and any other announcement for registration will be in line with first quarter for 2024. So courses are still available to register. You can still reach out to your friends. You can still reach out to family members who are interested in joining our mentorship program. And like we've said, our mentorship courses available are Our mentorship courses available are intellectual property, artificial intelligence and technology, the energy industry, fintech industry, health tech and law, the course the section that we're currently on, patents, then data privacy and protection, and then entertainment, business and law. Patent drafting and NFT, we are not currently hosting those programs right now on this quarter, but most likely, hopefully, we're doing that in the next quarter. There's still opportunities to have a 30 minutes one-on-one private mentorship with your favorite JIIPCC mentor. You can get hacks, secrets, life lessons, directions from your favorite mentor. If you want to register, you can just reach out to me or any of the member of the JIIPCC staff, and we'll do well to put you through. Going further, we want to introduce our mentor. Our mentor is Mr. Ebenezer Eguata. Mr. Ebenezer Eguata is a legal practitioner, medical law consultant, certified mediator, and a passionate patient's rights and safety advocate. He is a principal partner law firm's multidisciplinary consult, a firm that provides innovative legal insights and cutting-edge solutions located in Abuja, Federal Capital Territory, Nigeria. He is also the founder and executive director of Lawyers Arise for the People Initiative, LAPI rather, a patient's rights and safety advocacy NGO. He is a trained medical care assessor by International Medical Law Center, St. Kitts, North America. He is a member of Nigerian Bar Association, member Medical Law Professionals Association of Nigeria, member Institute of Medical and Health Law, associate member 3C MET International Institute of Mediation, Negotiation, Counseling and Conciliation, a member World Association for Medical Lawyers. He currently serves as the chairman Medical Law Committee, Nigerian Bar Association, Gariki Branch, Abuja. The chairperson, Ad hoc Training Committee, Institute of Medical and Health Law, and the legal team lead for Make Our Hospital Work campaign, a citizen-led community-based advocacy to improve the quality of healthcare services in hospitals and primary healthcare facilities across Nigeria. Ebenezer Ebenezer has also worked with Centers for the Rights of Health, a reputable NGO that is committed to health rights advocacy, and where he volunteered as program officer, legal/human rights program over a year, while at CHR Ebenezer, among other things, worked as an associate editor, researcher of the book The Right to Health and Violation of Patients' Rights in Nigeria, a Dex review on health-related laws in Nigeria, published by CHR in 2016. In the course of his patient rights and safety advocacy, Ebenezer has featured as guest discussants on different radios and television stations where he sensitizes Nigerians on their rights as patients and their available remedies in the event of violation or abuse. In 2021, through his NGO, he trained 189 nursing and midwifery students of FCT School of Nursing and Midwifery, Gwagwalada, Abuja, on promoting patients' rights and safety. The role of the nurse and midwives in commensuration of World Patient Safety Day 2021. He is an avid reader, a researcher, and he loves to serve humanity. That is our mentor for today, Mr. Ebenezer Eguatu. Our topic for today is healthcare fraud, abuse, medical practice, medical malpractice, patient rights, and evidence gathering. Once again, my name is Dennis Williams. I'll be your moderator for today. We would like to welcome Mr. Ebenezer as he gives us his section, his brief talk on the topic we have above.
Good evening. Can you hear me?
Yes, sir.
Hello,
Yes,
good evening.
Yes, sir.
Sorry, my video will not be coming up. Where I am is poorly lit, so no need of putting the video on. There is no light and the generator is getting fixed. So, it appears there is a mix-up in what was submitted to me. The material that was submitted to me is e-health overview, legal issues in emerging e-health, healthcare tech. Now, it seems we treated, this topic is similar to what we treated last week, but a different slide. I've been trying to get, I think there's a mix-up in what was sent. So that's notwithstanding, we will go ahead with the class. I think the questions that was also sent is along that line. So let the presentation be made. We'll take it up from there. Now, suffice to say that when we talk about fraud and medical malpractice, it is a deliberate deviation. A deliberate deviation. Most times, let me start with fraud, a deliberate deviation from ethical practices of medicine. Underline the word deliberate deviation from ethical practice with the intention of making more money from the patients. So when you talk fraud, the intent there is to make more money, to extract more money from the patients. And it comes in different ways. One of the many ways is prescribing needless medication for the patients, albeit harmless. Now, you know that this patient does not really need this medication or even a medical procedure. Now, for those who prescribe is where the hospital, the owner of the hospital has a particular pharmacy they prescribe or they recommend to patients. So what they do is they do the prescription. They say, go to so and so pharmacy and get these drugs. Now, that drug may not be harmful to the patient, but the patient, after examination, doesn't really need those drugs. But the healthcare professional goes ahead to make that prescription. Now, that is fraud. Prescribing tests that are needless and are not required for the medical treatments. That is fraud. Prescribing surgical procedures that are not necessary or required. In fact, there was a thing that was 2 years ago, a syndicate of, they had someone who was a professional amongst them, but the remaining ones were whack. And what they do is they just tell people you have appendix, they open you up, whereas there is nothing there that requires surgery. In fact, there was one person, one of their victims, they purportedly operated on for appendicitis and hernia, whereas nothing like that was required. Now, these are just bits and pieces, few examples of medical fraud. Then we talk about medical malpractice. Malpractice is also a deviation from ethical practices. But here the intention might not be to make gains, even though sometimes it ends up for those who do organ harvesting. But beyond making gains, you are causing the patient harm. That is more instructive. That beyond making monetary gains, for the person who is into fraud, yes, along the line, the patient might suffer harm, particularly, or not harm per se. His intention is not to cause the patient harm. Okay, he's opening the patient up for surgery and closes it where the patient suffers no harm. Because, of course, surgical procedure demands that the patient's body be opened up. Agreed. But for the person who is into medical malpractice, remember that one of the principles we talked about last week is the principle of non-malfeasance and the principle of benevolence. Now, you must not cause harm. The principle of do no harm when you talk about medical practice. Here, you now have a healthcare professional who deliberately sets out to cause a patient harm. How? Example, in the case of organ harvest. Once again, I don't know how many of you that followed the story in Jos, just like that last month. This is October, early September. Even though the NMA, Jos chapter, has come out to deny the man as not being a medical practitioner, but they all know him, and over the years, he has been there practicing medicine. He harvested a woman's kidney. A woman went there for treatment and all that, and he opened her up and harvested her organ, one of her kidneys. So now that is a clear case of medical malpractice. Again, I don't know how many of you who followed the case of the boy in Lagos. It was also in September. Unfortunately, he died. He went to a private hospital for treatment. By the time they transferred her to a government hospital, I think Luth, it was discovered that his small intestine was missing. He eventually died. Now, these are clear cases of medical malpractice, which ordinarily are punishable both by our law and by the Code of Medical Ethics. By that I mean, not Code of Medical Ethics, by the Medical and Dental Council of Nigeria. Because medical malpractice is a criminal offense. So the doctor, while not only being penalized by the Medical and Dental Council, his professional colleagues, he is also bound to be tried under our criminal law jurisprudence. So that is basically my introduction on fraud and medical malpractice. Then you come to patients' rights. Generally, what is patients' rights? Patients' rights are those rights that guarantee 1, professional, 2, quality, 3, safe, 4, and transparent healthcare to the patient, as well as guaranteeing the respect for the dignity of the person of the patient while receiving care under a healthcare provider. Now, by the time we are done with your presentation, I can do a further breakdown, and then we discuss evidence gathering, how as a patient you can gather evidence while receiving care, so that in the event of the undesirable, you will have something to back yourself up and seek justice. Now, we also have a litany of patients' rights, a good number of them. Starting, we mentioned a few last week, from right to information, to right to informed consent, to right to refuse treatments, to right to complain, to right to confidentiality, right to privacy, right to religious observation, and all that. So in the course of today's class, we will look at all those rights. Thank you very much.
Thank you very much, sir, for that brief introduction into the subject matter for today. I want to again apologize. I want to apologize for the mix-up in the topic sense. The topic sent for presentation, we sent the topic on health, e-health tech, where we were supposed to send it on health tech fraud. But irrespective, like Mr. Niza has already said, the group can still carry on with their presentation on that.
What did the students prepare for?
They prepared for the
what?
Sorry, sir, can you hear me?
Yes.
Okay, they prepared for preparation? They prepared for the e-health tech. It was a mistake.
They prepared for
health.
Yes. Okay. The mistake was from the management, right?
Yes, sir.
Okay. Now, if they're prepared for e-health tech, let's take what we have prepared for and push patients' rights to next week. Is that okay?
Yes, sir. That is okay, sir.
Me, I don't have issue taking the topic with or without the materials. Do you understand? But for them, yes, this is what they have prepared for. So let's take what they have prepared for.
All right. Thank you very much, sir, for that.
I thought they had patients' rights and medical fraud, while this was mistakenly sent to me. So I thought they had medical fraud and malpractice, patients' rights and evidence gathering. I thought that's what they had. But that's why I said the class could go on if I was the only person who didn't have the slides. But if this is what they have prepared for, e-health overview, legal issues in emerging healthcare tech, let's go on with this topic. Since that's what they have prepared for, then in our next class, we take patients' rights and evidence gathering. Is that okay?
Yes, sir, that's okay. Thank you very much, sir, for understanding,
okay,
sir.
Awesome.
Yes, sir. So we'll go over to the mentees. You can now have your presentation. Group presenter, you can come up and share your screen.
Good evening, everyone.
Good evening.
Good evening.
Yes, you are.
Yes, good evening. Okay, welcome to today's class. I'm Kali Victoria, and
can you all please turn on your videos? Let me know who is in class and who is not. You can put on your You can be here, then you are cooking in your kitchen. You can be here, you are doing something else. Just put on your video, then you can turn them off. Let's know that you are present. Okay. Okay.
Okay.
Okay. Okay.
So
Where
please,
is
there's no
Carlo?
light there.
Carlo,
So there's
your
no
video
light
is not
there.
on.
Yeah.
Okay.
So there's no light there.
Okay. Okay. Obegolu, Brian, Ordinaka, then Victor Moses.
Please, can we all comply and also turn on videos?
Award. Then for the person who took permission now that there is no lights, who was that again? That there's no lights. Award extra mark. Then for those whose videos are not coming on, deduct any mark for attendance today. Maybe you can deduct 2 for
Right,
the persons who took permission before. Who said there was no light? Think it's Calio.
Yes, sir.
Yeah.
Okay, so she's present. So let the presenter go ahead.
Okay. All right, I'm coming. Oh, Jesus.
You can go ahead and share your screen.
Okay. Can everyone see my screen?
Not yet.
Not yet.
Okay.
Okay, if you are having difficulties sharing your screen, please someone from the group should help her share the screen for the presentation while she makes the presentation. I'm sure you guys have the work with you, so you can open the slides and help her share.
Okay, thank you very much. Our topic today is legal issues in emerging healthcare tech. And we are going to be looking at the legal issues that we face in health tech. So our world generally right now is a global village. We see everything going global, ranging from our business, our education, our career. We even see like e-lawyering. Lawyers now go to courts from the comfort of their home. Everything is going global. Same as the health sector. And the world is really changing. COVID-19 pandemic actually made everybody go global. Everybody had to stay at the comfort of their home and see their medical doctors and do everything without going to the hospital with walls. So we're just going to look at everything having to do with the medical profession, the patients, and the community at large. So now, what necessarily is health technology? Okay, what necessarily is health technology? The World Health Organization has defined it as the application of organized knowledge and skills in the form of devices, medicine, vaccine, procedures and system developed to solve a health problem and improve quality of lives. So from this definition, we can see that the health technology has been defined as the application of organized knowledge, meaning that the technology or the devices do have the capability to perform what like a medical doctor ought to do. So as health tech is being advanced, developed, consumed, and used, there are challenges and issues. So this presentation is going to be bothered about the benefits, disadvantages, regulations, and everything having to do with legal issues of emerging healthcare tech. So now let's look at the benefits of e-health. Like we see that there are different benefits of e-health. And like I just mentioned, during the COVID-19 period where doctors were able to communicate with their patients through probably video conferencing, they were even able to communicate with other doctors far and near their jurisdiction. So e-health has done so many things for us. We can drive out so many benefits from it. One of those is that e-health improves significantly the quality, access, and efficacy of healthcare for all citizens. Yeah, then the second one, we see that ICT in healthcare is powerful in monitoring the outbreak and spread of diseases. Yes, we can see that ICT has helped a whole lot in every sphere of life, including healthcare, and they have been able to monitor diseases, able to monitor our globe to be sure that to be able to know when sicknesses or a particular type of diseases is emerging. So ICT has done us so much good, e-health has done us so much good. So another one, e-health has transformed the health system by incorporating electric means to deliver information and provide health-related training. Like, I'll still keep on hitting the example of COVID-19, where we had to do conferences with other doctors and the rest. So doctors were able to learn, and they were able to transfer information from one person to another through the use of ICT, through the use of e-health. So yeah, it has been able to provide training, it has been able to provide different things for medical practitioners. Fourthly, we see e-health technologies and processes such as individuals, electronic health records, clinic decisions, support system, and intelligence, respectively, and equipment have enabled the delivery of safe, high-quality health care. The culture of healthcare has evolved substantially from the days where mistakes, error, omissions, and duplications were common in healthcare delivery. I remember when this COVID-19 happened, I was still in secondary school. They were heavy on health, they were heavy on sanitation. So we had this electronic sanitizer that was on the wall that will make sure that every student passing will be able to sanitize their hands, will be able to clean themselves. So that is what technology has done for our health records. So we have been able to practice a healthy culture, a healthy healthcare culture. And now there's e-health has helped for medical practitioners to be low on mistakes and errors while conducting their health activities. Moving on to the next slide, we also see continuation of benefits. We see that e-health has enabled training for long distance supports, like people that are not in the same jurisdiction, that are not in the same environment. E-health has been able to help them to still, it's just like what I said before, to still be able to communicate and transfer information from one person to another. Okay, with ICT in healthcare, it ensures that information and communication technologies are effectively mobilized to develop health outcomes and fight diseases, even in isolated populations and remote areas. So that's all about. I'll just be brief. That's for it on the benefits of e-health. So now let's move further to the importance of e-tech. Like I said earlier when we started, that everywhere is going technological, everywhere is going online. Like I even said, even lawyers now perform their cases online. They deliver brief online, so as also the medical sector. So e-tech has like one of the importance of e-tech is that it gives or grants access to patient information for efficient healthcare. Yeah, we can easily access patient information. Just like now, our devices in our phones or our devices in our systems can be very limited, but we can have space in the cloud, or medical practitioners can have space in the cloud where they can as well always access their patient information. So patient informations, they always have 100% access to patient information. So another one, it also reduces paperwork because everything has been documented electronically. Like if you go to some places where you find whole lot of books, you see that rats and even some other rodents start attacking that place. And the hospital is supposed to be very neat and a place where it's very comfortable for people. So with the use of e-tech, one of the importance of e-tech, it has been able to help medical practitioners to as well keep their environment clean, keep their environment safe, because if those rodents keep on coming, more diseases will be coming as well. So it helps them to be able to store informations, to document their patients' details electronically. So yeah, the rate of medical errors or risks will reduce as every information has been documented. Yes, in electronically. So the rate of mistakes and errors will actually reduce. Let's explain it. Okay, when people operate digital healthcare environments, it gives them more reasons to know what is wrong with their health as it is within the reach. Okay, let me say for us to know when we did not have technology, legal practitioners, I don't know how they actually carry out their test, or they don't really know the issue with their patients. They have to carry out series of tests and series of tests and series of tests. But now, with the use of e-tech, they can be able to know exactly what the issue is instead of carrying out a whole lot of tests on their patients. So it also gives people the platform for confidentiality that they want. Yeah, it gives people like the platform for privacy, for please just keep my information private. I don't want it to go out. So e-tech has been able to help individuals to, or help medical practitioners to be able to protect the private life, the privacy of their patients. And it helps to preserve breach from their private life. Now we'll move on to the next slide. The key feats of e-health. First one we are going to look at is patient care. Okay, this involves the use of technology such as electronic health, record online patient portals, and telemedicine to improve.
Sorry, pronounce the topic of this slide again.
Key feats. Hello.
We can hear you. Keywords.
Key feats. Key feats.
Facets.
Okay, thank you, sir.
What does it mean?
Okay. Okay, key points of e-health.
Okay. Key aspects, facets, different aspects of e-health. Now, it's a class, so holistically, we should learn.
Thank you, sir. Noted. Okay, we're looking at the key facets of health, of e-health. That's the key points or key aspects of e-health. First one we are going to look at is patient care. Okay, this involves the use of technology such as electronic health record, online patient portals, and telemedicine to improve patient care. So, like, yeah, e-health helps medical practitioners to improve patient care, meaning that they even have the ability to take patient record. It's easier for them and it's faster. So patient care is actually increased. Second one we're going to look at is public health. So e-health now makes it easier to conduct health data analysis and public health surveillance. So spread of diseases tracked through e-health. So actually helping the COVID-19, so they were able to tell the public that you need to wear your face mask, you need to also use your hand sanitizer, you need to wash your hand frequently. So they were able to know what they could do to preserve the public from contracting or contacting these diseases. The third one we are going to look at is research and development. No, one of the major benefits of technology is the ease in conducting research. Can even see, sorry, I'm going to drive back to lawyers. We can see for lawyers, we have access to the law pavilion where we have they can have ease of conducting research and development. So it's easy to be able to how to conduct research with the e-tech view of their patient issue and know what exactly to do, the drugs to give, and everything they need to do. So we are still going to look at the ethical aspects of e-health. Next slide, thank you. The ethical aspects of e-health. The first one we are going to look at is autonomy. Okay, this is a general ethical fundamental of care. The patient has the right to accept or reject any technology, and that decision should be respected. Like, we can also see the fact that everyone wants you to do something to me or do something. If I have my meaning, you should also seek my consent before you do that. So yeah, these are ethical aspects of
Your line is breaking.
Yes, you're having a bit of network issue. Please, can you hear us? Victoria?
For your patients to decide for themselves. Then the second one we look at is privacy. Privacy. Patients have the right to conceal or disclose their private information to choose it.
Okay, it seems she's having a bit of network issue. Is there a backup presenter? Does someone else have knowledge about since you all conducted the research? Is there someone with a backup with knowledge on it that can serve as the backup presenter?
Good evening, everyone. I'm the backup presenter.
All right, Aka, please, you can go ahead from where she stopped.
Okay, let me share my screen. Can you all see my screen?
Yes.
Okay, sorry about my voice. I will continue from where she stopped. She was talking about ethical aspects of e-health. So she discussed autonomy, the fact that the patients have the right to accept or reject any form of technological treatment, just like most of us that are law students. In the case of that Jehovah's Witness child who was treated, and after everything, the child's parents sued the medical professionals to court. I did think that child was an adult and had his own decision to make, and probably he said he shouldn't be treated, and those medical doctors treated him, then the child can sue and decision, and the court would give or grant decision to his favor. So in a situation whereby a patient refuses treatment, or a patient rejects or accepts treatment, it should be respected. You don't force a patient to be treated. So secondly, privacy. Under privacy, patients have the right to conceal or disclose their personal information. A patient might decide to disclose his or her personal information, or decide to hold it back. So thirdly, we have confidentiality. This has always been crucial in the medical practice, and medical personnel should keep to themselves whatever they know about a patient. So under confidentiality, it should be noted that a medical doctor is not, does not have the right to disclose what the patient have told him, especially when most of those things are to the detriment of the patient's future. Even if the patient is dead at that particular time, he still have that right to keep those informations that the patients disclosed to him. So the next slide, ethical aspect, still continues. You know, we're talking about ethical aspect of e-health. So the fourth one is informed consent. If we can remember last week, there was a differentiation between consent and informed consent. So informed consent basically means that the patient's consent should be sought before any medical treatment will be carried on that particular patient. In a situation whereby you want to do an operation, or you want hello, can you guys still hear me?
Yes, we can hear you.
Yes, I can hear you.
So in a situation whereby you want to carry out any form of medical operation, or anything you want to do to a patient, first of all, there should be an informed consent from that particular patient. Then the fifth one, equality of service availability. As e-health brings better medical technology, it should also come up with cost-effective and accessible technologies, especially to lower socio-economic groups. So, in as much as we welcome this e-health, it's equally important that everyone should be treated equally, both those that are in a better position and those other persons that are not. Everyone should have access to this e-health. Okay, let's move over to e-health regulations. E-health, also known as health information and communication technology, refers to the use of information and communication technology, ICT, in support of health and health-related fields, such as healthcare services, health surveillance, health literature, and so on. So we've defined e-health according to WHO before now, and according to WHO, e-health is the use of information and communication technology for health. So that's basically the meaning of e-health according to WHO. And it's equally important to state that regulations often mandate strict controls over the handling of patients' personal health information to protect their privacy. For instance, the Health Insurance Portability and Accountability Act, HIPCC, FAA in the United States. So there are a lot of regulations regulating
It is
e-health.
called HIPAA.
Sorry, HIPAA. Thank you,
HIPAA.
sir. Okay, so there are a lot of regulations both in Nigeria and outside Nigeria. So e-health regulation covers data privacy, certification, and duty of care. They ensure patients' data protection as seen in HIPAA in US and Canada e-health Act. So in Nigeria, the Nigerian Data Protection Act 2023 governs data handling. And then also the NITDA 2007 supports ICT systems, including its use in healthcare. Security of electronic health records is priority with encryption and access control. Certification programs like the ONC's Health IT Certification Program ensure standard and Can we still hear me?
Yes, we can still hear you.
Okay, regulations.
Yes, we can hear.
So just like I said, there are a lot of regulations that controls e-health, both in Nigeria and outside Nigeria. E-health adoption in Nigeria comes with risk. In as much as these regulations are there already, it doesn't still exonerate the risk that it comes with. So as a result of that, we're going to be talking about the challenges of e-health. There are 4 major challenges of e-health, which includes 1, security and privacy concern, technical and infrastructure challenges, accessibility and health literacy and patients and engagement challenges. So these are the major challenges that is facing e-health as electronic health. Then also, there are legal issues in emerging healthcare. Legal issues are legal questions that require the courts to answer. Hence, the Nigerian National Health Act 2014 has provided a framework for the regulation, development, and management of Nigerian health system. There are a number of advantages. Remember, I talked about challenges of healthcare. In as much as there are challenges, let's not forget that there are a lot of advantages that we gain from electronic health. These advantages include improved communication, storage of big data, improved patient care, and so on. And in as much as there are disadvantages, there are equally some legal issues which will be considered. Some of these issues include breach of protected health information, altered data may lead to incorrect healthcare diagnosis, risk of misinformation, and so on. So conclusively, the use of technology in healthcare has a great deal of potentials, but it also comes with ethical issues that must be addressed. The key considerations include informed consent to use data, safe and transparency, data privacy, and so on. Policymakers need to ensure that these ethical issues are tackled proactively so that the benefits of technology outweighs the risk. Thank you very much.
Thank you, Odinaka. Thank you for helping us, serving as a backup presenter. Thank you for preparing, and also thank you, Carlo, Victoria, for starting off with the presentation. We would like to have Mr. Ebenezer come up and give his observation based on the presentation that was made.
Okay. Let me commend the group. This is well researched. Well researched. I just have a few observations and corrections and general inputs to make. Number one is that your slide is too busy. Some of the, even you, as you were reading it, you could notice that you couldn't see some words clearly because the pictures are conflicting. Yes, it's good that you design your slides. If you are putting these pictures as background, you fade them. Right? Can you hear me?
Yes, sir, we can hear
Hello?
you.
Yes,
we can hear you.
If you want pictures as background, if you want these pictures as background, you can fade the pictures. So, hello?
We can hear you, sir.
We can hear you, sir.
Someone interjected. Okay, in the alternative, you can put your pictures by one side, still communicate your message. So, when next you're designing, the pictures are okay, but the placement, it made the whole slide very busy. And you shouldn't struggle. One should not struggle. Look at your slide 6. You read the first sentence there. You will see that the word, is it efficient healthcare? You see that efficient is lost. You see that document on the second line is lost. You may pronounce it document because you already know, but you are not seeing the word, the words well. So your slide is busy. That is one correction I have to make here. If you're putting pictures like this, fade them so that one can see what you have. Secondly, on issue of privacy, when you talked about that's slide 8, ethical aspects of e-health. Privacy does not mean that the patient has a right to conceal or disclose his or her information, personal information. Now, you need to get this distinction clearly. A right to information is two-way. Number one, patients owes the hospital or healthcare right to disclose full information, of course, relevant information. As the doctor, you see, healthcare medication is prescribed or given based on age. A lot of information is required. So when you visit hospital, you owe the hospital right to relevant, truthful, honest information. Basically, age-related information you need to disclose. If there are symptoms, you need to disclose. The doctor looking at you by his training might know some things, and he will begin to ask you questions that you think are not related to why you are in the hospital, but you are not a professional. It's the doctor that has been trained. So you need to disclose that information. There have been cases, in fact, there was a case where someone told a lie, falsified her age in the office. She took away like 10 or 15 years in her record. And because that is what is her age, at least to their office, going to the office clinic, she can no longer bring down, come and tell her real age. They were now giving her medication that she's not supposed to be taking. And that caused another complication. The dosage she was being given and all that, she wasn't, so by her age, that medication was wrong for her. So when you talk about right to privacy, it is more on the healthcare provider side to protect the physical privacy of the patients. It is not, okay, I gave an example last week. When you go to general hospital, government hospitals, you will see that screen, blue-like curtain that has rails under. Has any of you seen that thing before? It's like a curtain. They can close it, they can open it. They can, do you understand? Yeah. So it is screen, like a veil. Now, when they want to open a patient up or to dress a wound, or a patient is going to, they are going to undress a patient or even give injection, they will use that screen to shield the patient, to provide relative privacy to the patient, such that a third party who has no business with that session of treatment should not see the nakedness of the patient, or even the wound that they are treating, assuming is an injury. So that is what privacy is about. Then you now talk about confidentiality. This now has to do with the patient's information, the patient's medical record. Anything that has to do with the patient's medical record, it is confidential. Now, patient's privacy, for example, you are doing e-health. Last week, we talked about telemedicine. Maybe a patient calls on phone and says, this, the doctor says, okay, can you do a video call? And the patient does a video call. The doctor says, okay, you said your left breast is paining you. Can you take off your clothes? Now, a third party should not be with that doctor at that point, except if that doctor, except if they are working as a team. By a third party, I mean, even if the person is a medical doctor but has no business with that particular treatment. For example, a professional colleague now, a healthcare provider, who is maybe a pediatrician dealing with children, babies. Then the doctor wants to examine his patients online via a video call. That pediatrician walking into the doctor's hospital, even though he's also a doctor, but as far as that treatment session is concerned, he has no business staying there. So he becomes a third party. If the doctor goes ahead to make that woman to remove her clothes, and that third party that walks in there, though a medical doctor, but has no business with that training, he is violating that woman's right to privacy. Is it clear?
Yes, it is.
Hello, I can't hear you. Okay, awesome. So
yes, sir,
that is clear. Right. That is right to privacy. Even in physical examination, where people go to hospital, maybe the woman is pregnant and she goes for antenatal care, and she is in she walks into the consulting room, and the doctor says, okay, she lays a complaint. The doctor says, okay, this, oh yeah, pull your clothes. If now, the first rule is, if a doctor is examining a female patient, if a male doctor is examining a female patient, a second person who is a female, either a nurse or a doctor, should also be in that room. So professionally, a male doctor should not examine a female patient alone, professionally. But because we have, how do I put it now? Exodus, mass exodus of our healthcare professionals. We have acute shortage of healthcare professionals now. There you have a situation where private hospital operators and other, most importantly, patients do not know these things. So if it is a physical examination, a lady walks in for antenatal consultants. If there is another doctor there who is a cardiologist, he has no business staying in that room. As that woman is walking in, he should be walking out. If he forgets to walk out, the doctor, the consultant, they should remind him to walk out to protect that woman's right to privacy. Then we talk about confidentiality. That has to do with the medical information records of the patients. It should not go into a third party's hand. It should not be released without the patient's consent, express consent. Now, we have cases where, I don't know if I mentioned it here last week, cases where persons who seek the services of house helps or maids subject them to tests. Fine and good. There's nothing wrong with that. Some say, okay, you have to undergo HIV/AIDS screening, you have to undergo hepatitis B screening, and all manner of screening. That is fine and good. But where after the screening, the result of the screening is delivered directly to the intending employer instead of to the person who underwent the test, is a violation of that party's right to confidentiality. The proper thing to be done is go and run your test. The hospital will give the test to the house help, intending house help or houseboy, provided that person is an adult. Then that person will now carry his or her result and give to his madam. We also have it in employment. Some organizations, part of their routine is health medicals. When you are done with your interview, the people they have selected who they intend to employ. In fact, sometimes it comes up during documentation. They say, go and do your medicals. Now, the proper thing to be done is when the people finish, they can go to the clinic, designated clinic, no problem, but they should have their results personally, after which they hand over the results to the intending employers. But where the company says, okay, this result will be given to us, it should be stated expressly. Then the person going for that test should write a consent, sign that he is consenting that his results be given to the company directly. That way, the laboratory and even the company saves themselves from legal liability of breach of rights to confidentiality. Now, if you look at that, slide 8, you will see under it shooterstocks.com, right, with the number. Now, that is telling me, that is showing me where you picked this picture. It's actually a copyright infringement now, because this picture is for sale. Okay, I can see, Ifunanya, you are surprised, right? Eh?
Yes, sir.
Okay, good. That's why you are in this class. It is not just the ethical law that you came to learn. Now, there are these pictures you see here are products for sale. That is why they are marked. If you pick it, it shows where you picked it from. So if you took this slide to make a presentation in an international conference, they can call you a thief, and rightly so, because you sold somebody's picture. If you had paid to gain access, and then we release this picture without this showing. So next time, if you pick such a picture, what you are supposed to do is to crop this off. So it is not good to do that. There are some pictures you can pick that are just free there. But any one of them you see that has a mark like this on it, it shows that it is for sale. So using it without payment, they can sue you. Now, what other correction do I intend to make? Informed consent. Who presented last? That is Chiamaka. Is that Chiamaka, right? Is that the name?
Odinaka, sir.
Odinaka. Okay, tell me the difference between consent and informed consent. You say something around that. So you need to understand these concepts. That is what differentiates you from the common man on the streets. So let's hear you.
Okay, so you mentioned it last time. You said that informed consent.
Mention what you understood.
Okay. You said that
what you understood. It's important that you understand it.
What I understood.
If you do not understand, ask question. Now, this is not to Odinaka alone. This is to everybody in the class. Don't quote me. Quote what you understood. Now, if what I said is what you understood, say it. I'm not interested in you quoting me. I'm interested in you understanding the concept and even putting it in your own language. Do you get me? Okay, so let's hear you.
Hello, sir. Can you hear me?
Yes, yes. Go ahead.
Okay, informed consent is basically the process by which
Yep. I can't hear you. Okay. Can any other person, you all are together as a team. So can someone explain to me what he or she understands by informed consent?
Okay, so let me explain.
I'd like to attempt. Sorry, go
Okay.
ahead.
Informed.
Okay, why don't we
go
take
ahead.
it? Why don't we take it one after the other? So I can see I think 2 or 3 people want to go to attempt the question. So you can just
let them raise their hands. You coordinate it. Then okay.
Do up one by one. So Jane,
your hand is up.
Okay. I understand that consent. I'll just give an example. A patient came for a treatment and then you give them a form to sign just like that. You tell them this is going to solve the problem, so you have to sign this first to go ahead. Meanwhile, in informed consent, you have to tell the patient everything about that treatment, the adverse effects, the things that the patient is to expect. Every minute detail is important. That's what I understand.
Okay. Okay, let me do it this way for better understanding. Everybody type on the chat box your understanding of the word consent. What is consent? Type on the chat box, what is consent? Give me an answer. Preferably one word. One word answer. What is consent? Your understanding, not definition. What is your understanding of the word consent? Give me one word. Agreement, permission, authorization. Next. Consent, permission from the patient. Okay. Yes. Permission, authorization.
Sorry, my network was disturbing. What's happening?
There is no problem. Just listening. Okay. Permission can go, authorization can go, approval can go. So you are all correct on consent. So I wanted to be sure that you understood that concept first. Consent is approval, permission, authorization, maybe validation of an act. No, validation may not come because it's after. But before the act is done, you are saying, I give you permission, authorization. I authorize you to do this. Now, I mentioned last week that the relationship, the doctor-patient relationship, is a fiduciary relationship, meaning that the power balance is not even. It's improper fraction. If you remember your mathematics, the power of the doctor is far outweighs that, or it could be 90/10. It could be 80/10, but never 50/50. So the patient is dependent on the doctor. If the doctor says turn, the patient just turns without asking question. How many of you have gone to receive injection? The doctor will just say, remove your clothes or pull your knicker, right? And you pull, he says, turn your buttocks, and you turn, and they inject you. Now, that is because of the enormous power the doctor has, which the patient is also aware of. So that turning, when the doctor says turn, and you turn for injection, you have consented by conduct, but that consent is not informed. So informed consent is that the doctor explains to you, maybe starting with the name of the medication. This injection I'm going to give you, this is the name. This injection will make you drowsy. So I'm just using injection or even medication, or even maybe surgery. The doctor will say, okay, this treatment option, let me use that word. This treatment option, these are the treatment options available. Option A, option B, option C, option D. Now, if we use option A, you are likely to go deaf. Maybe 50%, 70%. So it's 50-50 if we use option A. Option B is going to cost you maybe 100 million, and you don't have that 100 million to pay. Maybe option A that will make you deaf will cost you like 1 million naira. But the chances are high that you become deaf after the treatment. Option B is safe, but it is most expensive, 100 million, and you don't have it, and time is running out. Then option C will make you maybe stay at home for 6 months without going anywhere. Different side effects after the doctor has presented this to you and their cost implication. And after weighing everything, and you say, give me option A. As you are saying, give me option A, that is what we call informed consent. Why is it informed consent? You have been informed of the nature of the treatment, and you have been informed of the cost implication, and you have been informed of the side effects, probable side effects, and you willingly choose this particular one. You see the difference? Now, it is not the same as, okay, madam, this is the position, this is the situation. What we are going to do is we are going to amputate you. You were not given a choice to choose amputation. Amputation for the doctor is faster, is quicker, is easier. But if there are other treatment options that could take him like 6 months, it could even keep you in bed for that 6 months, but the doctor wants to quickly be done with this, your rotten leg, not your own though, quickly wants to be done with this rotten leg and move to the next patient. And the doctor now says amputation. Whereas that leg could be managed by other treatment options for like 6 to 8 months before the patient gets well and is able to walk again. Do you get it?
Yes,
Now,
we do.
what if we did skin grafting instead of amputating? It is more expensive, but it can work. So if the doctor says we are going to amputate and the doctor just chops off the leg, and the patient, maybe the patient was even in coma and wakes up to see that he now has one leg, the patient can sue because he didn't give informed consent. Now, for those who go for delivery, there is what is called consent form. It's a form, not just delivery. For surgical operation, surgical procedure too, there is what is called consent form. It's a standard form developed by the hospital. Now, what happens in most cases is, at the point they are willing the patient to the theater, they will now give that form and say, sign here. Because the patient wants to be alive, the patient will sign. But that consent is not informed. They are supposed to see the patient and say, okay, we are going to do surgery. Once we enter, they can even do a sketch and say, okay, once we enter, they are going to give injection here, maybe 3-4 points around the area. We call it local anesthesia to deaden that particular point where we want to operate upon. So they can even show you points of injection. Then they will now draw a line in the middle of that place and now say, okay, here, this is where we are going to open up. We are going to do this. We are going to do this. We are going to do this. After that explanation, they now say, okay, this is the consent form. You now read it that you have read and you have been explained to and understood the procedure that is about to be done on you, and you hereby consent. Then you sign your signature. That's a valid consent. That is informed consent. So do you understand the difference between the two? So that you are not just speaking English language, or informed consent sounds sweet. It is a concept that you must understand. Maybe by the time we begin to talk about patients' rights and informed consent properly, we deal more with consent, validity, vitiation, types of consent, what is a Gillick competence, who is qualified to give consent and who is not. So it is not just enough to say, I obtained informed consent. Can a minor give consent, whether informed or not? Those are the things we talk about. Then what is Gillick competence, which is an exception to a minor not giving consent. So we will get to know about all those. So those are the few corrections. Then HIPAA. Let's talk about HIPAA. That's slide what now? Just missed it now. Okay. That's slide 10. E-health regulations. Electronic health, e-health, also known as blah, 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 blah. Can anybody here tell me what HIPAA is? How does it operate? You see, what I want you to do, this is a training, yes, but I don't want you to just read it, gloss through it. Any concept you come in contact with, you need to know how it operates. Google is your friend. So you need to know how it operates. Now, what is HIPAA? Health Insurance Portability and Accountability Act. It's applicable in US. What HIPAA does is that it is a document that seals the right of the right of confidentiality of a patient's information, such that once that patient is an adult, nobody, including his parents, nobody can access his or her medical information except with his express consent. Now, it protects the patient's information. But if the person is a minor, the parents can wade in. But once the person is an adult, it's a no-go area. Even if it's emergency, the person is only the doctor can make choices. The parents cannot come and insist and say, no, this person is our son. No, 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 no. Now, to get a waiver, the person, most times, they sign a waiver for HIPAA to say, okay, I waive my rights. Then you put who should. In the event you are caught up in a medical emergency, that you are not in a position to make informed decisions or give informed consent. Your father, your mother, your brother, your sister should make these decisions in your place. Do you understand? So that is what HIPAA does, so that when next you meet it, you know that HIPAA is your friend. Okay, if there are questions, we will take the questions now.
Thank you very much, sir, for those observations. Those observations you made to their presentation. Now we'll be taking questions. If our mentees have questions that they would like to ask based on the topic they researched on, please, this is your chance. You can go ahead and ask your questions.
Good afternoon. Good evening, everybody.
After the questions, we have some students who were not part of the class last week who are joining us today. We had an introduction session last week. So those who were not part of your school, what you do, and got to join this program. So questions, please. Good evening.
Okay, I was not in the class last week, so I would also introduce myself. I'm a law student at the University of Nigeria, Nsukka. I'm a third-year law student at the University of Nigeria.
Okay.
So
are you related to Leonard Silk?
Sir?
Are you related to the Leonard Silk?
No, 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 no. We share the same surname.
Okay, okay. So,
yes, sir. So,
your question.
My questions are: does a husband constitute a third party in a medical examination? You gave the example of when you have a medical examination being conducted online, let's say through WhatsApp call, WhatsApp video call, or something. Does a husband or a sibling constitute a third party? Because I've been in an instance where I went to the hospital with my sister. She was feeling sick, and the doctor wanted to examine her. I didn't know the content of the examination, but he wanted to examine her, and he was like, I should please leave the room. I should leave the room so that he can examine her. So I want to know if a brother or a sibling or a husband constitute a member of the immediate family constitute a third party for the purpose of the medical examination. Then my next question is.
Let me ask the second question.
Okay, my next question is when medical records are needed for legal proceedings, maybe to establish maybe the particular person in contention is dead and is needed to prove the cause of death or to disprove the cause of death. In such a situation where such records are needed, how do you go about it? Does it amount to a breach of confidentiality if the hospital should release such records? Are there procedures to go about to attain such records in order for the purpose of that proceeding? And then my next question is, how can a hospital rely on a consent form to displace liability in a situation of negligence or misconduct which leads to injury or death on any of their clients or patients? And then finally, how do you balance consent and rest?
Take the third question.
Can a hospital rely on a consent form to displace liability for negligence or causing injury or death upon their patient.
Okay.
Then the last one is, how do you balance consent and res ISPA? Because we know res ISPA is the voluntary waiver of rights. So how do you balance consent and the contents of a consent form, an informed consent form to res ISPA? Is there a distinction between consent and res ISPA and informed consent and res ISPA? So those are my questions.
Res ipsa loquitur?
Yes, sir.
You mean res ipsa loquitur?
Yes, sir.
Okay. Now, what did you say is the meaning of res ipsa loquitur?
Res ipsa loquitur is like a voluntary waiver of rights, whereby a person assents to whereby a person is like he gives his consent towards a particular thing, and then he cannot be seen that he's now stopped from going back on his word.
Okay. Those of you that are law students, is he correct?
He's not, sir.
He's not,
Thank
sir.
you.
He's not.
Thank you. So, what was he supposed to say?
Res ipsa loquitur means the fact speaks for itself.
For himself.
Awesome. Now, from his explanation, what is the right maxim supposed to be?
I was meant to say voluntary non-fit injuria. Voluntary non-fit injuria, not res ISPA.
Voluntary non-fit injuria.
Yes, not
Beautiful.
res ISPA. I'm sorry for that.
Okay. Yes. I hope we are enjoying this. That's how I teach. You see, I'm not interested in what you're saying. I'm interested in what you understand. So if you're saying this, make sure it is this. So let me just put it out there. My style of teaching is not to embarrass anybody. So nobody should feel embarrassed. One, we are all learning. If you knew it, you'll be in your house. You wouldn't be here for this program. So you have no right to think in your head that somebody else does not know it. He or she failed it. No. So every correction you get here from me, born out of greatest respect for you and out of the desire to see you better. The one that we look embarrassing, I will do that in private. I'll call the person and speak to the person. So, but the ones that are not, that I consider not embarrassing, we do the learning together here. Now, those that are not law students, they have learned res ipsa loquitur, voluntary non-fit injuria. Good. So, your questions. Number one is whether a family member constitutes a third party. The answer is, once you are not a healthcare professional, you have no business there, except where the person is a minor, like a mother carrying her child to a hospital, maybe even a 14-year-old boy, a 14-year-old girl, 15, and the parents can stay at that point. But a 15-year-old girl who has developed, the father should not stay there. Now, there are some cases that, based on the intricate nature, okay, if the doctor is suspecting pregnancy, maybe the girl is saying she's having tummy ache and all that, and the doctor is suspecting pregnancy, and they have taken her to the doctor, either her mother or her father, the Nigerian mother or father is there. And the doctor now said, when was the last time had intercourse with somebody? And the girl now says 2 weeks ago or 3 months ago, in the presence of her mother. Two things are about to happen. Either her mother faints for the doctor to now leave the girl and start treating the mother, or the mother will start beating the girl in the presence of the doctor. First of all, her security or safety at that moment is required. So, right to privacy is tied to individuals, regardless of age. Once the person is an adult and of sound mind, and can talk at that moment, the person's right to privacy is sacrosanct. So whatever they discuss in there, the doctor will now know how to present to the parents what they discovered. We have a communal culture here where one person's problem is everybody's problem and everybody wants to pry into things that they have no business prying into. But right to privacy, as a family member, you are a third party. If the doctor deems it fit that you are not supposed to be there, that means the doctor wants to ask some private questions that you have no business. It's not just the examination is not just physical, maybe remove your clothes. No. The examination could be some personal questions. When was the last time you drank alcohol? And you come from a traditional Christian or Muslim home that has no business with substance and all that. And the lady or the young man says, last night. Maybe the person is complaining of stomach ache, one side of the stomach, and the doctor is suspecting kidney. But to make his preliminary investigation, he asks the guy, do you take agbo? And you know that most of the thing we call agbo is mixed with hot, right? Hot drinks, right? Now, it's not always necessarily because the doctor wants to do physical examination on the person. For a young lady, the doctor might say, when was the last time you saw your monthly period? It is her personal and private question and information. So you as the brother, even if you were there and they asked that question, you will walk out because you start feeling uncomfortable. Do you understand it? So a third party, a family member, that you're a family member does not give you right to breach your brother or sister's right to privacy. No, whether you're a senior brother or junior brother is immaterial. If the doctor deemed it necessary for you not to be there, you have no business being there. Number two, is there a procedure for obtaining medical record, right? Maybe it is needed in courts, right?
Yes.
Now, an order of courts is the right procedure. An order of courts can vitiate right to confidentiality of medical information. So where now another vitiating issue here is public interest. Maybe, okay, we just had the case of COVID. In 2014, we had Ebola. Dr. Stella Davo, God bless her soul, used her life to sacrifice for Nigeria to be saved from Ebola because she was the first to attend to that man. But that's an aside. If you notice that this person has a contagious disease that can put public health in jeopardy, you do not need court order to divulge that information. Do you understand it? If you notice that somebody has COVID, you can disclose that information to save the public. Because if the person goes out, the person will begin to spread the information, to spread the disease rather, and the public will be put at risk. So public interest can be a vitiating factor where the right to confidentiality can be a defense to a breach of the right to confidentiality. So a court order is there. If something is happening or there's a litigation and there is need for medical record, you write to the hospital. Now, if it is the owner of the medical record, he or she does not need court order. It's his record, he will apply for the hospital to provide it and he will be given. But where is a third party that needs it to prove a case to say that this person has this disease, which the person can seek for court order, giving sufficient reason why that order should be granted. Once the court makes the order, the hospital will release the medical information of that man. Then your third question, can an institution rely?
Can a hospital rely upon a consent form to displace liability for negligence?
Good. To escape medical negligence. That's where the case of voluntary non-fit injuria comes in. Now, voluntary non-fit injuria is one of the defenses to cases of medical negligence that he volunteered. Now, he never volunteered to be used as a guinea pig, even if he volunteered to be used as a research object. He didn't volunteer to be killed. He didn't volunteer to be injured. That is when we talk about validity of consent. If the consent was properly obtained, and the harm the patient is complaining about was properly explained, that this is what is going to be one of the outcomes of this experiment or research, that is where voluntary non-fit injuria will avail you. If you have the person, this research, this is what one of the likely outcomes will be this, or this one of the side effects will be this, and that eventually happens, it means that the man had given informed consent. So it's not enough to have a patient sign a consent form. That consent must be probed, must be questioned. How did you obtain that consent? Did you obtain it by misrepresentation? Did you obtain it by fraud? Is the patient competent to give consent? Does the patient have the mental capacity? Even though you have explained to the patient, does the patient have the mental capacity to understand the far-reaching implication of the side effects? It's like an imbecile whose reasoning power is retarded. Then you now say that the person gave consent because he signed the form. It will not work. No matter what you say, no matter the explanation, that imbecile does not have the mental capacity to process the far-reaching effects. So you now see why I spent time to explain informed consent. It is a big deal. So by the time we come to our next week's class, we will get to know more on consent. You asked the fourth question.
Yes, but you have already explained the fourth question.
Okay. So voluntary non-fit injuria means that a volunteer needs not to complain of injury. If there is a medical research that is ongoing and you volunteer to be used, some people do that. They can explain to you these are likely to happen. Now, for cases of plastic surgery, every other case is 50-50 chance. For cases of plastic surgery, voluntary non-fit injuria cannot absolve you. You know why? Plastic surgery, the patient has a desired outcome. The doctor is making a representation that I am able to deliver on this. You want to bring your nose under your mouth, or you want your nose, instead of being at the center of your face, to be taken to your left cheek. As a plastic surgeon, he says, yes, I am able to do it. Your money is 10 million naira. And he or she pays you 10 million and gives consent. What we want to see at the end of the day is that that nose has moved from the center of the face to the left cheek. So there is no amount of explanation you are going to give that instead of bringing it to left cheek, you took it to the right cheek. You are liable, because in cases of plastic surgery, the outcome are determined before you even start. They are agreed upon. So it can serve as an exception. Do you understand? So
Yes, sir.
next question, please.
Okay, sorry, sir. Please, I would like to thank you so much for answering my questions. But I would like you to clarify me on something. You mentioned public interest
Just hold on, let me shut
as
my
an
window. We are
exception to.
working on the generator so that the noise is not.
Okay, sir.
Okay, your question, please.
Okay, as
Go ahead with your
I said,
question.
I would like to, you mentioned that public interest is an exception in
Public
in
health
confidentiality.
interest, public health, yes.
Yes, public health. So, to what extent is required to ground such suspicion before you can now publicly declare
To
to
what
a third
extent?
party that such a person has an injury? Yes, is such suspicion required to ground the what extent is required to ground such suspicion in favor of public interest?
No, it is not suspicion. No. It is not suspicion here. It is what you know, what you are sure of. You can't suspect that somebody has HIV. You can't suspect that somebody has malaria. You cannot suspect that somebody has typhoid. You can't suspect that somebody has Ebola or COVID. You need to have tested this person and confirmed that this person has these ailments, which is a threat to the public. And even before making it open, it's not you just tested, then this person has this ailment, then you go on AIT and announce. No. You must have given this person precautionary measures. Like in the case of COVID, quarantine. Restrain yourself from public or the public assessing you and others are not. It is when the person does not comply with this that he becomes a threat to the society. It is at that point that you can make such declaration. And even making such declaration, there is a procedure. It is not you as a lab scientist is in hospital A, you just tested somebody and you saw this person has Ebola. You go on Facebook, I just tested a patient, he has Ebola. You'll be breaching his right to confidentiality. Do you get it? So it is when the person is adhering to the proper medical protocol to prevent the spread of that disease. If the person is insisting that he must go to church, he must go to a market, he must go to mosque, he must mingle with people, thereby raising the risk of spreading the disease. That's where even in that declaration, there is a protocol. So it is not that you just suspect that somebody has COVID and you go on air. You'll be accusing the person wrongly. Now, you must also understand the essence of tests is to confirm what exactly the problem is. Here we mix symptoms with ailments. Are you aware that headache is a symptom? Are you aware that fever is a symptom?
Yes.
So the fact that somebody is feeling feverish does not necessarily mean the person has malaria. That is why the doctor will ask some questions to say, did you do this? Is after all those questions they are asking you, they are using it to, how do I put it? They are using it to put facts together to confirm what their suspicion is. They are also using it to eliminate suspicion. If they suspect it could be this and they ask, do you do this? Do you experience this? If you say yes, they can say, okay, so it's no longer this one, it is this one. Until they get to what they want, then they can then recommend tests to confirm what they are suspecting. They have been trained in that regard. So, next question, please. Thank God, are you done? Okay, just give me 2 minutes, please. Let me sort this.
I'm sorry for the delay. I'm sure our mentor will soon be back with us. So please just kindly exercise a little patience. I'm sure he will soon be
back. Yes, I am back.
All right, thank you very much, sir.
Okay, so let's have the next question.
Okay, I can see Michael. Michael, you've been raising your hand. You can go ahead and ask your question.
Thank you, sir.
You're welcome.
My question is on duty of care, as the doctor's duty of care on the patients. So in a situation whereby the doctor refuses to administer treatment on the patient because of the fact that he hasn't completed the payment or he hasn't made any payments entirely, and at the cost, the patient sustains some kind of injury or death, does the patient have any right to sue the doctor for negligence and breach of his right to beneficence? Sorry.
Yes, the patient has a right to sue the doctor. Last week, I mentioned a case here. How many of you? I only got one response. You people didn't engage. If you are not doing my assignments, I will tell JIIPCC not to graduate you, not to issue your certificate. So you will come back. You see, this is an interesting course if you take it seriously. It is an everyday occurrence. It can happen to anybody, including you. So that's how serious what we are doing here is. And we set out to protect Nigerians generally. You see, once a medical doctor takes up a patient, okay, let me start by saying this. Section 20 of the National Health Act provides that, I read it out here last week, that hospitals in Nigeria should not deny patients treatment. It should not deny patients emergency care for any reason. Do you understand it? Now, whatever reason the doctor wants to give that made him to refuse treatment, under the law, that reason is not obtainable, or rather, tenable. That reason does not exist. To say it was because of this reason that made me not to treat him. In emergency situation. In emergency situation. Now, the underlying word is emergency. And I said what could constitute medical emergency. We talked about labor. A woman in labor. In fact, last night I was called that a woman in labor, she did her antenatal care at a primary health care center. For those of you in Abuja, there's a place they call Duse. She did her antenatal care at Duse. But because it is a primary health care center, they do not have the capacity to take delivery. So when she was in labor, she was referred to a hospital in Kubwa. And that hospital now said that they do not have bed. For that reason, they cannot take her in. Now, Section 20 of the National Health Act says hospitals should not deny patients treatment in emergency situation for any reason. Now, if the hospital had commenced treatment and the doctor now says he will no longer treat because the patient has not paid, now, that is, the doctor is still liable. You know, your first duty as a healthcare professional is to save life. Now, we must also draw a balance. Hospitals are not charity organizations. To get quality healthcare is expensive anywhere in the world, including Nigeria. So patients have the obligation and duty to pay under, well, hospitals should be. No, the law did not say that hospitals that should treat patients free of charge. That is not the law. The law is that where there is emergency, the hospital should waive primary documentation. You know, when you go to hospital, they will say, go and buy card. Then when you buy card, they'll say, make payments, go and confirm payments here. Has any of you had that experience? Now, those are institutional protocols for maybe tertiary healthcare facilities like teaching hospitals. From point A to B, before you could finish that payment to get card and come back, it could take more than 1 hour. We get to obtain the card, where you even get to make payments could be different, where you even get to go and get a form. Do you understand? Now, the law now says in emergency situation, waive this hospital protocol. It does not mean the patient should not pay. So where a doctor denies or refuses to treat a patient in emergency, the doctor, according to our law, not exceeding 6 months. So just imagine that the doctor is jailed and they ask, what did he do? Did he steal? They say, no. Did he defraud anybody? They say, no. What did he do? Just imagine it. There's also a fine of 100,000 naira against that healthcare professional if he's found liable. So it is a case of emergency. The doctor should commence treatment, stabilize the patient, then ask for payment. Also note that referral is medical service. If a case is brought to a hospital and the hospital says we do not have bed space now, That reason is legitimate because one of the principles of care, or basic care, is that you do not admit patient outside a bed. So you can't admit patient on the floor. Now, what the doctor or hospital is supposed to do in that circumstance is to write a proper referral note. That is medical service. Okay, at the moment we have seen this patient, these are the conditions. However, we do not have a bed space to admit this patient. So we are referring this patient to hospital ABC. You give them that referral note, they go to that hospital and get admitted. But where you just dismiss them, go, I beg, they go, we don't get space here. It is a breach of their rights, and they can go to court and they will claim damages against that hospital. Is that clear?
Yes, sir. Thank you,
There were some questions that were, yes. Dennis, can you read out those questions that were sent in?
All right, sir, I'll do just that. The first question here is, sir, a wife who is heavily pregnant.
Can see some. Yeah, go ahead, please.
Yes, sir. The first one is a wife who is heavily pregnant, who the husband has signed consent on her behalf, differs the information consent principle. That's the first question. I don't seem to really understand the question.
Whoever sent that question, can you take it?
Yes, Mary Ngozi, please, can you rephrase your question and ask?
Is she on call? Her video is off.
Can you hear me, sir?
Okay, yes.
Can you hear me, sir?
Yes.
Can you hear me?
Yes, go ahead.
Oh, okay, my question is, okay, it was when you talked about informed consent. So I'm asking, what if in a situation whereby a woman is heavily pregnant, then she needs to be operated, and the husband is being asked to sign a form, either maybe if anything, in case anything happens to the wife. So I'm asking if it is a breach to informed consent, as the wife was not informed, but
now
the
that is a
was now asked to sign on.
Now that is a wrong and wiped understanding and explanation of informed consent. People have that notion, even though it is wrong, that where somebody is signing where the husband is signing, it means if anything happens to your wife, the hospital should not be held liable. That's a wrong understanding of what consent is, but that is wrong. If the woman is okay and can read and can write and can understand the implication of what she's signing, the woman should sign consent form. I have also heard stories where a woman died because her husband refused to sign consent. What nonsense is that? And the husband will say, no, my wife she must deliver like the Hebrew women. She mustn't deliver through cesarean section. That's rubbish. If the woman is healthy enough, strong enough, whether she's in labor or not, if she can understand what's going to happen to her after explanation, the point here is after proper explanation, then she can sign. Even if the man signs the consent without proper explanation, that consent is invalid. That's what we are saying here. We must understand the procedure. My emphasis is on the mode of obtaining a proper consent. It is more important than the actual signing. So it is not enough to say, Oga, sign here. So that's the point I'm making. Women can sign consent, whether married or not, provided the person is an adult. It's her body, it's not her husband's body. So, but where it is an emergency, maybe the woman is in coma, maybe the woman is in such severe labor, such that she's not in a position to sign. Not just pregnancy, it could be any other type of surgery, it could be any other type of medical emergency, it could even be accidents, where the person whose body is going to be frame of mind or mental state to comprehend what's going to be done to his or her body. That's where a nurse of kin can come in. That is even where the doctors can take on, invoke paternalism and start treating. But once a person is an adult of sound mind, that person has a right to informed consent and should be the one to sign his or her consent form. So that is it. Next question.
Okay. The next question, can you hear me?
Yes.
Okay. The next question is, in line with recent trends in cyberspace in Nigeria, is e-health really applicable?
E-health has always been applicable. It has been applicable in Nigeria and other parts of the world. Now, last week I read out section 22 of the Code of Medical Ethics, talking about telemedicine, which is an e-health practice. So e-health has always been applicable. There is also the Cyber Crimes Act. Now, the issue with e-health is there is a responsibility or a duty on the healthcare provider to secure his or her patient's information, medical information. That's all. So if you have enough cybersecurity experts who can guard and protect your system and make it hack-proof, there's no problem. E-health is practicable and it is ongoing. In fact, there are some organizations that just provide the platform and have doctors subscribe to it. They have doctors from different disciplines. They have cardiologists, they have maybe pediatrician, they have oncologists, they have gynecologists. So if there is a call from a patient to the agency, that's how e-health operates. Someone registers a company, builds a platform, advertises it, now has doctors subscribing to his platform. So if there is a call, a gynecological case now, he will look among the 3 or 4 gynecologists that he has on his list and forward that case to one. The person consults with the patient. After everything, before this time, the patient had made some payments. So at the end of the day, the doctor who did the consultation gets his share, the company get their share. That's basically e-health. They provide a platform, a pool where patients could call in, then they supply the doctor to meet the case at hand. That's all.
All right, sir. Thank you very much for answering that question.
You're welcome. Next question.
It's in answering the first one. It says, are cybercrime laws applicable to e?
Yes, they are. Anything you're doing on the internet. Now, if you are a healthcare professional and you begin to stalk a patient, let's say a patient has HIV, and as a doctor, you now begin to use that information to threaten the patient, to say, okay, we have your record now. To blackmail a patient, we have your record now. So send me 1 million, or I tell your wife, or I'll tell your husband. That's a cyber crime. Do you understand it? If as a doctor you examine the woman and you discover that she has some medical complication that will make her unable to give birth for the rest of her life, and maybe you did that examination where she was single, and you hear she's married now, you now will say, okay, madam, you remember in 2013, you were in a hospital and you know your health situation, you cannot actually conceive. I don't know if you told your husband this, but however, if you don't send us 500,000 naira, we will disclose this information to your husband. That's a cybercrime. You are trying to blackmail the person. Then if for whatever reason you either deliberately or inadvertently release or cause to be released a person's damaging health condition, even though for me there is really nothing damaging about health. Nobody brings a disease upon himself except maybe some lifestyle cases. We will talk about HIV now. But I have seen a case where somebody got HIV by blood transfusion in the hospital. So was it his or her fault? No. Do you get it? Somebody was transfused in the hospital and he got HIV. So you now push that on the internet. This person has HIV. Every man should avoid her, or every woman should avoid her. That's cybercrime. You are tarnishing the person's image using the internet. A whole lot. So that is why there is a duty on the part of the practitioner to safeguard the medical information of the patient. That's all. So if you use your information about a patient wrongly on the internet to the detriment of the patient's medical or physical or mental health, you are liable. Not just the cybercrime law, our criminal law generally, our criminal law jurisprudence will be invoked against you. And there will also be professional sanction. So it's not just cybercrime law alone. Next question, please.
All right, sir. The third question is there any major difference in e-health? Is there any major between health technology and e-health?
Okay, when you talk about health technology, the E there is just electronic. Do you understand? Anything that is being done on the internet is e-health. Anything medical that is being done on the internet is e-health. But if you talk about health technology, you know that there are Apple wristwatches now that can regulate your blood pressure. Are you aware?
Yes, sir.
There are different gadgets that people wear that are good for their health. There are acupuncture gadgets that people can you just sit on or stand on it depending on the acupoints, and they will just, those are technologies. That Apple wristwatch is technology, it's not electronic. Even though the Apple Watch itself is electronic, but you can't call it e-health because it's not happening on the internet, even though you can connect it to the internet and do whatever you want to do. Now, there is this electronic blood pressure reader now. Unlike the old one, do you understand it? And they'll be reading. There are a lot of technologies now. So the E is basically electronic, representing the internet, not electricity. So we must get that differentiation proper. So if it is, let's say, if it is tech, health tech, it has to do with technological inventions. Are you aware that there is bloodless surgery now that is being promoted? Do you understand it? That there is even technological surgeries that could be done. They will insert camera through your mouth and they will go and remove appendicitis in your stomach without cutting you open. That is technology. Are you aware that there are e-surgeries? That you are in Nigeria, somebody is in China operating on you through a computer. They will set everything that needs to be done. The man in China is queuing on what should be done on your body in Nigeria. Robots are there. Artificial intelligence is there. Robots are doing wonders in medicine. So those are technologies, health technologies. But if it is on the internet, even though some of them are intertwined, like the example I gave for the e-surgery now, the patient is in another city, another continent altogether, but the internet is linking them. So you see a combination of technology and the internet. Do you understand it? So just know, once the procedure does not involve the internet, it's purely health technology. But if it has the internet to deal with, it becomes electronic. So is the differentiation clear enough?
Yes, sir, I think that's clear enough, except if any meant.
So are we done with our questions?
Okay, there's one more question, and that I think the last question on the chat box. The question is: in case of plastic surgery, can a surgeon be held liable if there are certain complications resulting from the surgery, even after a patient gave informed consent?
Yes. You know, I gave a funny example. Now, plastic surgery is basically changing your body parts. Do you understand it? You're not basically changing your body parts. That's a wrong one. Your body structure, the way you are looking. Some people can say they want to collapse their cheeks, and people have done it. Do you understand it? Some people can say their cheek, they want it collapsed, they want it to go in. Surgically, it is possible. They can do it. Have you people read about the man that turned himself to a dog? Hello?
I saw, yes, I saw that on the news.
Now, that is plastic. You shouldn't just see it on the news. Read and follow up. Now, that is plastic surgery. People are doing crazy things to their body. Some people can wake up and say they don't want their teeth, their natural teeth again. They want to replace it with gold. People are doing that. Some people can wake up and say they don't want to have fingers again. They want to now have claws. Plastic surgery, that's the madness we are getting into in the name of rights and pushing of person, me, I. So now, plastic surgery has a predetermined outcome. Some people are reducing their mouth. Do you know that your lips now, you can make your lips thicker and bigger? You can make your lips look like the lips of a pig. Yes. So the plastic surgeon can do anything on the human body, on the human skin, to just reconstruct, body reconstruction. I think that's a better word. So if you have a desire to reconstruct your body, you now say you want your ear to be on your forehead. Do you understand? You are laughing. You say you want your ear to be on your forehead. They can chop off your ear and surgically plant it on your forehead. Now, that doesn't mean that your eardrums and all that and the internal workings of your ear. No, but you know the funniest thing, are you aware that this your ear you can hold, this physical part of your ear you can hold, are you aware that it provides balance to your body? That you may not walk straight if those two things go off. As little as it is. So, if someone engages a plastic surgeon and say, I want this, the plastic surgeon, once you are taking up that, you have consented, yes, I am available and I can deliver this. Have you seen people who go for BBL? It's plastic surgery now. Those people that go and do their bomb, Abi, it's plastic surgery that they do. But have you also seen the ones that turned out bad and they are rotting? Have you seen the pictures or videos? Now, such a person can sue, whether he gave informed consent or not, except where he or she was told that with the type you are paying for and the type we want to do for you, there is a 50% chance that after 1 year, it will begin to rotten. Or you must be coming every 6 months to take this injection so that it will remain firm and not collapse. So if you miss coming to take this injection, it is possible that it will collapse or it will begin to rot. So if the lady fails to take that injection, it becomes a defense. We call it contributory negligence. So if the lady fails to come and take her injection on the 6th month, and something begins to happen, you don't hold the doctor liable. If the doctor finished his surgery and everything was okay, and the lady went about, but there are subsequent medications or treatments that the patient is supposed to be taking or undergoing, and the patient misses out, the liability is no longer on the doctor, but the doctor has the duty to prove that this is the cause. Not me, the patient caused it. Is that okay? So I think we have come to the end of our class for today, if that is the last question. But before we go, we had the people who have not introduced themselves to the class. So if you are in that category, we have seen Mr. Brian. So the remaining persons, turn on your video, tell us your name, where you reside, what you do, and why you chose medical law. Thank you.
Thank you. Thank you very much, sir, for that very, very interesting, interactive and detailed step-by-step section. We want to now take those people who are yet to introduce themselves to the class. Just like Mr. Ebenezer said, can you turn on your video? It's the first time you are on this class. I don't know, Zainab, is this your first time? I can't remember seeing you in the last class. So is this your first time here?
Yeah. My first time.
All right, please, can you introduce
yourself? It's not my first time. Okay.
Sorry, what?
Yes.
Yeah, you can go on.
My name is Abani Mary from Ebonyi State. Ebonyi State University, Faculty of Law. I'm a student.
Okay, what level?
200 level.
200, okay, awesome. Next person, why did you choose medical law? Why did you choose? There is intellectual property, and under there is fintech. Why did you choose this?
In my school, we don't do health tech law. We do intellectual property as a elective. That's why I said I want to know more about the medical field.
Okay, awesome. Are you related to Dr. Charles Abani?
No, sir.
Are you related to Dr. Mark Abani?
No, sir, but he's from my place.
Okay, oh, you know them. Awesome. Okay, great. They are good human beings. Okay, next person. Any other person? Zainab, were you in the class last week? No?
Yes, I was. Sorry.
Oh, really?
Yes,
okay,
sir.
so if Naya, were you in the class last week? I doubt.
I was, but I did not
Interesting.
introduce.
So you didn't introduce yourself, right? So why are you making us shout? Introduce yourself.
My name is Adikese Mefunaya. I'm from Imo State and I attend
Pronounce that name.
University.
Pronounce your first name.
Adikese Eme.
Okay, okay. Yes, continue.
I attend Igbenedion University. I study law and I'm in my final year.
Awesome. So why did you choose medical law?
I chose medical law because I think, okay, I want to know more about law in the medical sector. Health is like a very important part of my life, and I should know my rights, I should know my limits, I should know what the law is, so that if somebody infringes on my rights, I'll be able to know what to do. And
Awesome.
yeah, and a lot of people do not know that they have patients' rights. That is why they can take anything that is being done to them in the hospitals, because they feel that the doctor knows better. So they just decide to keep quiet, and then some people die as a result of that. I just want to know more about it.
Okay, that's good. Do we have any other person who didn't introduce his or herself last week? Mr. Dennis, do we? I don't think so, right?
Yeah, yes, I think that's all for today. We don't have any other new persons, sir.
Okay, if you have your announcements, you can take them. I have an NGO, Lawyers Arise for the People Initiative. It is a patients' rights advocacy NGO. I usually provide opportunity for students here who want to volunteer for us or with us. I also usually get students here who are interested in preparing my slides, because I have training engagements for hospitals. I build the capacity of doctors and hospitals generally, healthcare professionals along patients' rights, avoidance of medical negligence, and duty of care. In fact, just last night, I got one for December. I'll be training a group on duty of care. So what I do to strengthen the hands of participants, and they have opportunity to see some materials outside the course content here. Of course, if you are preparing my slide, you are reading the materials I'm sending. I will send you this material you prepare. Now, it provides them opportunity to see those materials and see the practical aspects of these things we are saying here. So I usually give opportunity for each set. Now, it is not mandatory, one. Two, if your studies will not allow you to do that, you are not bound to do it. 3, it is voluntary. 4, you can say no even when we send you what to do and you don't have that is in conflict with your work. So you can say, for this reason, I won't be able to deliver on this. So if you are interested to do that for us, you reach out to us. What we usually do is, if the need arises, we also write. We've written to, okay, one is here to get back to me on the outcome. I said it last week. What's that her name again? Oh, God help me. Samantha. She's a Zambian, a Zimbabwean, but based in Ghana. She volunteered for us, and there was a volunteering opportunity with AU African Union. We had to write a letter of commendation or a letter of attestation telling African Union to absorb her because she has worked for us. So now that doesn't mean you should come and work so that we write a letter for you. So that's it. So over to you, Mr. Dennis.
All right, thank you very much, sir. We want to really appreciate all you do for us, sir. You took out your time to really give a detailed explanation into the topic. We want to also apologize for the mix-up in topic. We'll be making the corrections in the WhatsApp group of the mentees of the. I'll be sending a message to make the correction this evening. And Mr. Ebenezer is also on the WhatsApp group. So if you are interested in volunteering, you can drop a. You'll be able to see it. So thank you for joining in for today's class. I'll be sending in the attendance and everything you will need to fill in after this class. So thank you once again. Thank you again, Mr. Ebenezer. We've come to the end of today's call. Thank you once again.
Thank you.
Looking forward to.
Go and read the 2 cases I mentioned. The doctor in Plateau State, Josh, that harvested the woman's kidney. You read the case of the boy in Lagos whose small intestine was taken away. Next week, we are discussing medical malpractice, medical fraud, and patients' rights. So go and read up on patients' rights beyond your slides, and let's engage next week. Thank you.
Thank you, sir. All right, goodbye and enjoy the rest of your evening, everyone.
Thank you, sir.